We move on to defenses based on choice. What if you have no choice but to commit a crime? Can you think of a situation? Emergency situations. Let's consider, I'm going to give you 3 examples and then we're going to talk about the law and apply it. So let's look at this. Let's put this into context. Donald, who is charged by a raging bull, hits it with Vicky's priceless vase, destroying the vase but diverting the bowl. Is Donald guilty of intentionally damaging Vicky's property? Because he did. He intentionally took the vase and broke it over the head of the bowl. Let's compare it to this. Marty tells Ken that unless Ken steals Joan's lawnmower, Marty will kill him. If Ken steals the mower, will he be guilty of larceny? Suppose the threat is to destroy Ken's Mercedes. Is there a defense to any of these? Ebenezer sees Marley coming at him with what appears to Ebenezer to be a machine gun. May Ebenezer pull out a pistol and shoot Marley, or must he wait until Marley actually shoots at him? These scenarios coincide with the defense of necessity. Let's talk about necessity. Under the Model Penal Code, conduct which an actor believes to be necessary to avoid harm or evil is justifiable, provided that the harm/evil sought to be avoided by such conduct is greater than that sought to be prevented by the law. Okay? By the law that defines that offense. So you have to ask yourself, what is the lesser of the 2 evils? So let's skip back to the bull. Donald, who is charged by a raging bull, hits it with Vicky's priceless vase, destroying the vase by diverting the bowl. Is Donald guilty of intentionally damaging Vicky's property, or does he have a defense? And based on necessity, he avoided being run down by a charging bull by breaking a vase, which is the lesser of the 2 evils, the breaking of the vase. So here, Donald would avoid being convicted of a crime. Marty tells Ken that unless Ken steals Joan's lawnmower, Marty will kill him. So if Ken steals the mower, will he be guilty of larceny? Well, what's the lesser of the 2 evil? Like stealing the lawnmower or being killed. So in this instance, he will not be criminally convicted because he would have the defense of necessity. He was justified in stealing the lawnmower because Marty was going to kill him. Now, Marty might be charged with a crime, but that's what we're not talking about that one just yet. Suppose the threat is to destroy Ken's Mercedes. What if Marty says, Ken, steal the lawnmower or I'm going to destroy your Mercedes? So we have a damage to property or stealing property, which is the lesser of the 2 evils. Does it matter that it's one over the other in this case? I think destroying the Mercedes would be more expensive than stealing the lawnmower, but can you steal one person's thing for the sake of avoiding harm to your own thing? Let's take a look at the 3 elements. Maybe we could solve that one. So you have more than one harm. The harms are ranked by seriousness. Objectively reasonable belief, the greater harm is imminent and can only be avoided by committing the lesser crime. I know I have the bull case down here, but we've already talked about it. So the Mercedes, probably destroying that Mercedes is going to be more serious than stealing the lawnmower. I don't even think you can get a really, really expensive lawnmower that would trump having damage to the Mercedes. So he might get away with the defense of necessity in this instance. All right, you are one more example here for necessity. You're lost in the woods. You're wandering around, no food, no water, it's getting cold and dark. You find a cabin. You try the doors, they're locked. You pick up a rock, you break a window, and you climb in. Inside, you eat food, drink water, and you stay warm. And then you call law enforcement. Or maybe the owners show up the next day and they find you sleeping on the couch. You're arrested. They call the cops. You're arrested for trespass and burglary. Do you have any defense? Well, do we have more than one harm here? Well, you broke in, breaking and entering. Let's say burglary is breaking and entering, or trespass, one of the two, because you don't really intend to commit a crime therein. You tend to eat some food and stay warm. Do you get a trespass charge? Well, you could have died of starvation or exposure if you stayed outside. So you avoided the harm by going inside or trespassing. And this sounds like a very good opportunity to say necessity. The defense of necessity applies in the first instance. But while you're there, you take the cash and the jewelry that you found in the drawer. Now, can you say necessity? Nope, you can't. What if you get there and somebody is there? Someone's at the cabin, you bang on the door, cabin owner opens the door, and you say, I'm lost in the woods, and I'm starving, and I'm cold, and the cabin owner refuses you, slams the door in your face, and then you kill the cabin owner for refusing you. Is that okay? Lesser of the two evils there? No, because the risk on the third one is higher. The harm is ranked higher or more severe. So that's how the defense of necessity works. Let's move on to duress, where the actor engages in conduct because he is coerced to do so by the use of or threat or use of unlawful force against a person. Is this Ken in the last case where we had stealing the lawnmower? Could we call that duress as well? That sounds more like duress than necessity. But still, you could still probably use necessity in the other one as well. But it might be more of duress, where the actor engages in conduct because he or she is coerced to do so by the use of threat of another. And we have three elements that we have to meet for duress. Someone faces a threat of death or serious injury. There's an objective belief only one way to avoid that threat is to commit a crime. But number three, very important, that crime cannot be homicide. So let's talk for a moment the difference between our necessity and duress. What's our difference between necessity and duress? Duress is the cause of another person. Necessity, an act of nature, act of God. So when we shuffle back to the Ken issue, where Marty has got a gun or threatening Ken in some fashion, can we use necessity there? These are the things I kind of want you guys to think of when you're analyzing quiz questions or one of the forum posts or one of the assignments. You got to kind of pick through these elements. It sounded pretty good for necessity, but when you look at the elements, what's the difference? Duress is going to be caused by another person. Someone faced with a threat of death or serious injury. And the other one, necessity, seems to lean towards more an act of God or nature. So let me see, I think I have another example. Mark finds his, oh, this is the one we're going back. We had this one a little earlier. Mark finds his wife in bed with another man. Mark goes up to his wife, puts a gun to her head. hands her a knife and says, "Stab your friend until he is dead, or I'll kill you and our children." And she does it, and she's arrested for murder. Can she claim duress in this instance based on those elements? Remember element number 3? The crime committed cannot be homicide. So you can't take one life to save your own life. It's one, you can't kill somebody and then say you were under duress in doing it. So that's the one exception. Back to Marty, right? Marty tells Ken that unless Ken steals Joan's lawnmower, Marty will kill him. If Ken steals that lawnmower, will he be guilty of larceny? Well, in this instance, duress? No, he won't. Okay, and the same thing relative to the Mercedes, but under the defense of duress. All right, one more example, and then we'll move on to the next offense. A fire sweeps through a residential neighborhood. Cory and Joe, they know a lot about fires. Maybe they were volunteer firemen back in the day. They light their neighbor's house on fire to create a fire break. This prevents several houses from burning, including Cory and Joe's houses. But then they're arrested and charged with arson. Do they have a defense? Is it duress? No. How about necessity? They're faced with two harms. We have the loss of several houses, burning down one house, loss of several homes to one. Is it reasonable? What could happen? Is this if it works, is it a perfect defense or an imperfect defense? Do you think they should burn down their neighbor's house in order to save several houses, including their own? This might, this has been a question for, a jury. This is one of those things that a defense attorney is going to have to prove by a preponderance of the evidence when they raise affirmative defense of necessity. And you're sitting on a jury and you hear those facts. That could go, that's one that could probably go either way. You want to say yes. And I'm leaning towards saying yes, but on the other hand, you could totally see that not working out either. Perfect or imperfect, if they're successful, then it's a perfect defense. There'd be an acquittal. There wouldn't be a lesser included arson charge involved. It would be a straight up acquittal. Consent as a defense. What is it? Consent. Most of the time you hear consent relative to sex offenses and crimes. We'll discuss more about those crimes a little later, but we're going to talk about consent with the non-sex offenses. And what's key about consent is that the victim chooses to render the conduct. When someone gives consent, it must be done knowingly, but it must be done knowingly and voluntarily. The law will define when consent is ineffective. When would consent be ineffective? Person's too young. They're a minor. Person who is mentally incompetent. Someone who's intoxicated. What if you're forced to consent? That's not knowingly, right? Duress by deception. Consent is not knowing, and it's not voluntary if any of those things exist. Person's too young. Person is mentally incompetent or intoxicated. Someone who's forced or tricked by deception. So when consent is given, it has to be done knowingly and voluntarily. So let's take some examples. You are at a college frat party and everyone is drinking away. Someone decides it would be fun to play the kids game, pin the tail on the donkey, and despite the actual poster of a donkey, a party goer who has had several drinks, decides he wants to be the ass that everyone can pin the tail on. He is stabbed several times in the butt by Bob, and Bob is charged with assault. Can Bob use the defense of consent? What's our drunk party goer? Can he actually knowingly and voluntarily give consent? No, he can. Bob probably cannot use consent unless they can show that the party goer voluntarily and knowingly gave consent. So Joe shows up at this party and he's sober. Bob grabs Joe and says, "Go stand in front of the donkey poster and be the frat ass." Joe says, "Cool, I'll do it." And he does it, and he's stabbed several times in the butt by Bob. And Bob is charged with assault. Do we have consent here? Yes, we would have consent here. Your parents are away for the weekend and you have to watch your 8-year-old sister. You're not happy about it, but you do what you have to. You take your sister with you and your friends to a bow and arrow practice. Your friend Joe is an expert shot and hits the bullseye often. Your sister thinks he is the best. After seeing a scene on TV with a guy shooting an apple off a girl's head, she asks Joe to hit an apple off her head. She runs out to the target, places an apple on her head, and Joe misses and slices her ear off. He is charged with assault. Do we have the defense of consent here? No, because your 8-year-old sister is probably too young to consent. Alan and Brett are both football players on opposing teams. During a high school football game, Alan tackles Brett and Brett is seriously injured. Can Alan be charged with assault? No. Why not? Consent, right? This is a prime example of consent. When you actively participate in a sporting event that could potentially cause you some injuries, like playing football, you cannot have the other person charged with a crime. You have perfectly consented to that. One final example that I want to share with you because it's crazy as all can be. This was a real case. Somebody, let's say a bunch of friends go out to a shooting range, and one of the friends had recently purchased a bulletproof vest, and they wanted to try that bulletproof vest out. So they have it on and they ask one of their friends, "Hey, shoot me in the vest." And guess what happens? They miss. The shooter misses and hits the person in the shoulder or in the neck. Pick your spot, but they survive. Let's say we don't kill that person off. Do we have consent in that case? How do you feel about that? Well, here is when consent does not work. Consent is a defense to only a few crimes. Sexual conduct, we'll talk about that when we talk about sex offenses. Injury occurring during a sporting event, that's just what we talked about with Alan and Brett. And crimes not resulting in serious bodily injury or death. And in the instance that I just gave you, the person who shot the gun could probably be charged with some sort of reckless assault, because you should certainly know the level of circumstances, and you can go back and review the mental state for recklessness, but that's what it would fall under, consent or not. That is something that you would be charged with, and you can't say, well, they wanted me to do it, they consented to do it. Same thing with the apple and the bow and arrow. If it wasn't an 8-year-old individual, but somebody who was, like, say, in their 20s or of age, and that happened, that would be something that would not be consent. So that's how consent works. And we'll be moving on to insanity next.